A relatively brief judgment issued earlier today by Judge Anthony Miller, roughly 14 pages, crisp and succinct. And when it was sent to me and I hadn't opened it yet, I thought, I wonder, because I remembered when argument was happening last week. Was it last week? I think it was. Judge Miller said, but, if he's sequestrated, if his pension is attached, what's he going to live on? And I thought, I don't know. Frankly, I don't care, but maybe Judge Miller cares. Not so much, it seems, because he said, pay back the money, total of 28,960,774, and don't forget the 34 cents. That's the gross sum, plus interest on 18,261,347.72, which was the initial amount determined by the state, and that amount was in play between 22 October 2021 and 24 January 2024, both days inclusive. So interest on that over that time, and then interest on the full sum of 28 million plus from the 25th of January to date of payment, which will be, we hear a chorus of, never! But theoretically, within 60 days, failing which, there are consequences, writ of execution, and so on. Karyn Maughan, he's never going to pay any money, is he, Karyn?
Well, I think that's why the DA sought the orders that it did about, compelling the state attorney to essentially, if he fails to pay that money, and I'm sure he will no doubt appeal this, but essentially saying to them, look, you've got 60 days to get the writ of execution, and then you can attach property or the pension, and you have to keep reporting back to the High Court every 3 months about your progress in getting this money back. So that was one of the reasons that the DA articulated. They said the state attorney just took too long to act on the Supreme Court of Appeal 2021 decision, and they want guarantees that that's not going to happen in the future. But as to your original point, I think we would all be very, very surprised if that money got paid back.
Because he will inevitably appeal this, and he will lose it at the SCA, and then he will appeal it to the Concourt. He will lose there, and then he might or might not apply for a rescission of the Concourt judgment, and if he does, he will lose that, and by that time we'll all be dead. A meteor would have struck us and ended this pathetic excuse for civilization through which we live.
Well, that's quite a nihilistic, apprehension of the entire situation. But I don't think you're necessarily wrong in regards to the Jacob Zuma issue. And what's so fascinating with this, of course, was during the argument, the counsel for the presidency actually said, the reason that we need this order is because, quote unquote, this man never pays anything. He had a judgment against him for 7.6 million rand about that VBS loan that he got for the Nkandla upgrades. And, in court, it came out that that had not been paid. I'm personally aware of huge amounts of cost orders against Jacob Zuma that have not been paid. And I don't know that there's any record of him in his personal capacity, whether it was a state capture litigation and the slew of other cases that he has lost, actually paying costs for that litigation. So I think that, what's interesting about this one is that I think a lot of other litigants, particularly if the state is involved, just simply abandon those cases because, it's death by 1,000 paper cuts. But we have a scenario where the courts actually said to the state attorney, if you don't do this, you're going to be in contempt of court potentially. The scenario becomes somewhat different.
Yeah, because the state has to report back. It has to say at these regular intervals, this is what we've done since last we reported back. And does it bring in the possibility, I don't know, of a contempt order against the State Law Office for failing to take the actions the court has directed it to do? Because, yes, this amount was asked for and has now been decided must be paid, but do you sense any appetite for whoever is responsible for taking action on this within the state law setup to go ahead and attach Jacob Zuma's property?
Well, they can't attach Nkandla because, of course, we know that it's owned by the Mgonyama Trust, and Helen Ziller said as much in the court papers. They've said, we're aware that he gets a salary as a president, we're aware that he gets this pension, and we believe that this could potentially be attached. And, they now have an order which would allow the SCA, which would compel the SCA to then embark on that court process, which of course would also be very protracted, because Jacob Zuma is likely to revive those arguments of what am I supposed to do, or how am I supposed to survive, which is really one of the core arguments he made in this case. But I think what is somewhat problematic for him is in this context where so much money is owed to so many people, that there is again this relentless appetite for pursuing the so-called Stalingrad litigation that the state is now attempting to stop in the context of his corruption trial. So I think it's going to be quite difficult for him to continue pursuing those cases in the context of an environment where he is now on the hook for 28.9 million rand that was used to file those cases in the first place.
A listener asks about the attorneys and advocates who benefited from all these legal fees. That didn't come up, so it's not part of the court record. But do you think there's some kind of moral pressure on them to return some of their money, Karyn?
Well, it did actually come up at some point with the state attorney. Isaac Chawe responding to Jacob Zuma, arguing that the state attorney should recover this money from the estate of his late advocate, Kemp J. Kemp. And Isaac Chawe is saying that was a rampantly inappropriate suggestion, because the lawyer had been paid to the benefit of Jacob Zuma. There was a suggestion, I think, during the arguments in court that if Jacob Zuma wanted to pursue that kind of litigation and try and get the money back from his lawyers, he could try and do that. But essentially, this money was spent for his benefit, and so it should be recovered from him. And in Anthony Miller's judgment, he says, look, the SCA's orders are completely, apparent. They're very clear what they mean. I mean, Jacob Zuma in the case, in an argument that was pursued very vociferously from his advocate, Tabani Masuku, was saying, well, I have been a victim of this terrible negligent legal advice from the state because I litigated in the way that I did, because I believed that the state was funding me. To which, of course, Anthony Miller said, I don't know if you really want to make the argument that you wouldn't have litigated like this if you didn't have a deluge of taxpayers' money paying your way. But that, in essence, is what was the argument.
And Karyn, surely we are beyond the point at which a de bonus proprius order should be issued for lay listeners. That is when a court says that the lawyers must pay the costs of a case out of their own pockets, because what they are arguing is clearly legal nonsense. Because Zuma's, you and I have spoken recently about the NPA's attempt to bring Stalingrad process to an end. Trial must continue. Any further appeals happen after the trial and verdict. But appeal, Stalingrad. Lawyers, Dolly and Paul included, making nonsense arguments, being slapped down in increasingly exasperated language by courts of first instance and higher courts. Surely the time has come to start saying to the people who are standing up and arguing for Jacob Zuma, it's such a crap argument, pay.
Well, I mean, there have been attempts to get that kind of cost order de bonus proprius in the past. Not least of all was in relation to, obviously, his attempts to appeal the invalidation of the private prosecution, which we got. We argued for a de bonus proprius cost order because we said, listen, this is essentially an unwinnable, futile case. But as yet, the courts haven't granted those.
Yeah.
And, I think it's all about an issue of saying, why is Jacob Zuma treated so differently to the rest of South Africans? Because, the average litigant, if they pursued the level of pointless, futile litigation that Jacob Zuma has pursued, they would be declared a vexatious litigant. Arguably not in the context of a criminal trial, but certainly in some of the other cases that he has brought. And if there was a scenario where he was, huge amounts of money had been spent by the state on defending, itself against those sort of futile prosecution attacks, arguably there would be a greater effort to recover that money from the litigants involved to ensure that they could not pursue this in the future. But for whatever reason, there seems to be a bubble of deference even to this day, around Jacob Zuma that has effectively shielded him as much as that taxpayer's money has. And that's the real heart of it. I mean, Johan Krickler actually said, quite a few months ago, and I completely agree with him, until such time as judges start drawing the line, and in some ways, like Anthony Miller did with a 14-page judgment that just says, look, the court has said what the court has said, I have no choice, pay back the money, and judges stop allowing him to continue in this kind of strange Stalingrad litigation in his corruption trial, he is going to continue to abuse the legal system because the system is allowing him to do that.
Karyn Maughan, as always, thank you very, very much indeed.